European Court of Human Rights has now decided it will allow the International Commission of Jurists to make arguments in the case of whether Caster Semenya should be allowed to run in her choice distances as a woman. The case is being held as Semenya versus Switzerland, because she's appealing a decision by a Swiss court, which has jurisdiction over the Court for Arbitration in Sport, which is based in Switzerland. That court said that international athletics authorities did have the legal right to say she could not run in the 800 meters events unless she took medication to lower the amount of testosterone in her body. Kajal Ramjathan-Kyo is the director of the International Commission of Jurists Africa program. Kajal, good afternoon to you, and thank you for your time. So you're now allowed to make arguments in this case. What are you going to argue?
That's correct. Thank you, Stephen. So, first of all, to give you a little background to the case, it has been proceeding for several years. In April, the International Association of Athletics Federations issued eligibility regulations on female classification, and this is specifically directed at athletes with differences of sexual development for specific races, and this is the 400 meters, 800 meters, hurdles, and 1500 meters event. Caster Semenya was affected by these regulations. She challenged them at the Court of Arbitration for Sport and was unsuccessful. She has filed appeal, which has not been finalized. That is ongoing. But what she has done now is file the case before the European Court of Human Rights against Switzerland for the reason that the Court of Arbitration for Sport is based in Switzerland. So the case is brought against Switzerland by Caster Semenya, alleging that Switzerland has breached her human rights by imposing these regulations on her, which affect her ability to participate in international sporting events. So the International Commission of Jurists have applied to intervene in this case, and the submission we will make to the European Court will deal primarily with issues of discrimination, so issues of international law, the fact that states have a responsibility to protect against discrimination and ensure equal protection of the law. The ICJ submission will not deal with any factual issues, and the focus will deal primarily with international law issues.
One of the curious aspects of this, as I understand it, is that the athletics authorities say she can run some distances, but not the one she wants to run. I mean, in other words, the claim would be the regulation has been designed just for her, just for Caster Semenya.
It sounds pretty outrageous that the 800 meters, which is her specific race of choice, she's unable to run in. She may compete in the 5,000 meters, but that is not the race that is not her race of choice. So there are certainly some difficulties with the regulations. There's a huge deal of interest in the case. Caster Semenya is not the only female athlete who is affected by these regulations. There are several other athletes whose names might be quite recognizable to your listeners. Rwandan athlete Francine Niyonsaba also fell short of these regulations and was not allowed to participate. Namibian athlete Christine Mboma is similarly affected. So there are several athletes who are affected by these regulations. So it is a really good opportunity at this point for the European Court of Human Rights to listen to the submissions and to come up with a decision, which hopefully we can't say in which direction it will go, but to come up with a decision that will make competition for female athletes in international sport more fair and equitable.
The Human Rights Commission, so our Human Rights Commission, is also going to be making arguments, and I think this is the first time that a Human Rights Commission from an African country is being allowed into the European Court of Human Rights. And again, it's an extraordinary case in so many different ways. Do you think your arguments and their arguments are going to be quite similar?
Well, we haven't seen the Human Rights Commission submissions yet. The thing with applying to the European Court of Human Rights is that you need to show what submissions you're going to make, and you also need to show that those particular submissions are different to submissions that other parties may make. So if the ICJ has been accepted and the South African Human Rights Commission have been accepted to make submissions, it is very likely that those submissions will differ on various points. There's also serious restrictions on the length of submissions, so it's probably a very good idea that several parties who are interested in this issue do get an opportunity to make submissions, because each submission is very, very brief.
When we go into a South African court, I know which law we're arguing under, right? It's a little book, it's a little constitution. I don't go anywhere without it, and I know some people might find that a bit sad. I just call it dealing with politicians in 21st century South Africa. So I know what that constitution means, I know where the Bill of Rights is, and I know what those rights are. Which law are you arguing under? Because it's a European court, it has jurisdiction over quite a few countries. It's a court really for the EU. Switzerland's not part of the EU, just to make it even more complicated. So which laws are you arguing under?
So the ICJ submission will focus on the prohibition of discrimination under a particular article in the European Convention regarding the enjoyment of convention rights. It's Article 14. It will deal with the extent to which discrimination is permissible under international human rights law and standards, including under the European Convention. And this will also deal with the limitation of particular rights and which limitations are permissible and which are not permissible. And finally, the submission will deal with rights to access to justice and an effective remedy in international human rights law and standards, looking at particular sections of the Convention. So submissions are restricted to looking at particular sections of the Convention, and we will be restricted in those submissions to the European Convention.
And I hate to ask this question, but if she loses here, is that it? Is there nowhere else to go?
Well, so because there's still an appeal ongoing in Switzerland, that is one further place that she may use to ventilate her situation and try to get effective remedy for her situation. But it certainly is not the end of the road, and she can appeal to several UN human rights bodies. So while this tribunal would be extremely important for Caster and for other athletes in her situation, it is certainly not fatal if this application is not successful.
Kajal Ramjathan-Kyo, thank you very much indeed, Director of the International Commission of Jurists, the Africa Programme. It's an important story relating to Caster Semenya and, of course, her future.